Namaskar, good evening India. The Constitution of India confers on every citizen certain fundamental rights. Article 21 says, no person shall be deprived of his life or personal liberty except according to the procedures which are established by law. And a real implementation of this article can be seen in the functioning of the Central Administrative Tribunal, or CAT as it is popularly known as. Established in 1985, over the last 26 years, about 6 lakh cases have been instituted in CAT, and a whopping 95% plus, you heard it right, 95% plus have been disposed of. Under the chairmanship of Honorable Justice V.K. Bali, the last 5 years of CAT have seen significant progress, and to help us understand that journey, we are now joined on Good Evening India by none other than the Honorable Chairman himself. Justice Bali, a warm welcome.
Thank you.
How close is the tribunal to dispose of a case within 6 months?
Amit, the tribunal is established for a twin purpose, which is speedy and inexpensive remedy to a central government employee. Now, when this is the object, the tribunal would not live up to its name and reputation, which is unable to decide a case as early as possible. And it's heartening to tell you that despite the fact that since 2008, we added jurisdiction to a tribunal by adding 185 institutions, with which the filing in the tribunal has gone just double. In principal bench at Delhi, just double. And outlying benches also, work has increased tremendously. Now, despite that, insofar as the Central Tribunal at Delhi is concerned, last 3 years we have shown disposal at the rate of 120%. With outlying benches, you just now said, is 95%. Now, we have to do it. Otherwise, the expectation of people for which the CAT is made would be frustrated.
But Justice Bali, what is it that CAT is doing differently than the established system of court? Because often when we talk about the pending cases in the established court, one laments about the huge pendency, huge time that it takes.
But you see, it all depends. Now, let's talk about High Court first. I have been a part and parcel of High Court for 16 years. The workload in High Court is tremendous. Every case conceivable under the sun is entertainable and triable by the High Court. The judge's strength commensurate to the work is very little. There is always a need to increase the strength. But I may tell you, I can tell you for my High Court particularly, and well, other High Courts also, even the sanction strength has never been up to its brim. Not only up to its brim, sometimes it's just the half and 1/3. Now, with this scenario, you can't expect High Court to be disposing cases as early as tribunal can do. The judges are few, workload is tremendous. So, therefore, perhaps only an idea was conceived to separate a part of the branch of law from High Court and to vest it with a specialized tribunal. And where it may be taking time in High Court, as you said, the reasons I have given you. But tribunal, we are trying to see through that the object of the act is achieved.
So, the objective that it started out with in 85, over the last 26 years, do you see that the tribunal has effectively fulfilled those objectives?
Well, the facts and figures speak for themselves. Just now I told you, from 2008, after we added to the jurisdiction, and we may tell you, we didn't ask government even to give us one extra post, even of a peon. With the same infrastructure, with the same number of people, employees, judges and all that, we have worked. The pendency or filing or pendency has just doubled.
So, when you joined in 2007, what all
services? It was
3,500
say per year.
3,500.
Now it's 7,000.
And how many services were included in 2007, which has increased to 100?
From 2008 to 2009.
Yes.
185 institutions.
185 institutions.
Yes,
now within the
some institutions which have massive litigation, like National Highway Authority of India, PCI, AIMS, MCD, DDA. They are storehouses of litigation, you know.
And apart from the central government and the state government
Yeah,
employees?
that's right. No, state government we are not doing. Only central government.
Only central government across
and
India.
central government employees and all organizations or institutions which are centrally funded, which were not earlier there, which alone have come in the last 2-3 years by my persuasion of the government, which I told you 185. Now, despite that, if we are able to dispose of 120% cases, now filing is say 65 or 7,000, disposal is 7,500. So we have made a name, we are an object, and we have dedicated a lot of people with us to see to it that a case, life of a case in tribunal is not more than 6 months.
So certainly, Justice Bali, that is a very heartening news that the case can be disposed of within 6 months. Under your chairmanship, as you said, the scope of jurisdiction has increased many-fold. The disposal rate is so nice. Would you then say that tribunals have become an effective and real substitute for the high courts? Or why is it that sometimes the judiciary or even the government stop short of saying that a categorical yes, that yes, it's a substitute for high court?
Government is saying it's substitute to the high court. But let me correct you a little bit. I take credit for what you have said under my chairmanship, but I tell you it's basically a teamwork. I have a dedicated team with me. I can't do everything. Now coming to your next question, what did you say? I just
would you say it's a substitute for high court now?
Yes,
the tribunals?
I just missed the link. Across the board, government says it is a substitute to the high court. In the initial stages, even the Hon'Ble Supreme Court said so. In a very important case known as Sampath Kumar. But that view was doubted by the Hon'Ble Supreme Court itself. And a larger bench, well, they didn't say substitute, but they said supplement to the High Court. But nonetheless, one branch of law which was done by High Court, whether you call it supplement or you call it substitute, is done by the tribunal only.
But the people who feel aggrieved by a decision that comes from the tribunal today, they can go to the High Court still, and we need to kind of plug that loophole.
You are right. This is what exactly I was telling you. In Sampath Kumar's case, the Hon'Ble Supreme Court said our statute provides appeal to Supreme Court only. And Supreme Court upheld it. Which view has been changed now to say judicial review is basic feature of Constitution, and this power of High Court judicial review cannot be taken away. But this has led to you asked me a question, is very relevant. In the present scenario, is very relevant. This question, when this judgment came about, actually government wanted to abolish CAT. Now they thought, this was government's, I'm telling you first government's view, and then of course I give the Supreme Court. Government thought that this tribunal was made for a twin purpose of, as I told you, speedy and inexpensive justice. Now, if an order of CAT is amenable to a challenge to the High Court, there are the tiers at it. You first come to CAT, then go to High Court, and then go to Supreme Court. So the purpose is defeated.
Yes.
Now they thought if purpose is defeated, why have CAT at all? Then they constituted a parliamentary committee headed by MP Nishapan, very competent. I have gone through his report, very competent person.
Mr. Sudarshan.
Yes, you are right. Sudarshan Nishapan,
yes.
Something. Now he went into matter in great details, examined legal luminaries, top lawyers, judges, former chairman of the CAT, public at large, employees, and the government, and gave a big report. He said, don't abolish CAT. This is one of the rare institutions in the country which has kept pace with the time and really helped remove the grievances of government employees. Therefore, CAT was retained. Otherwise, government was thinking of abolishing it because they thought the object is defeated. But now there is development. And development is that Justice A.R. Lakshmanan, a former judge of Supreme Court who became chairman Law Commission, He went into in-depth study of this whole scenario and gave a report which is known as Law Commission's 215th report, where he has very strongly suggested the government that you either make a presidential reference to the Hon'Ble Supreme Court for revisiting its judgment in that larger constitutional bench known as Chandra Kumar's case, or alternatively to make suitable amendments in the statute and the constitution so that the order passed by CAD is amenable to appeal only in Supreme Court. The government also was serious. I also, they asked for my view. When I gave my view, the Law Minister, Mr. Boyle, at that time, he arranged a high-powered committee meeting which consisted Solicitor General of India, Attorney General of India, Law Minister of himself, of course, and Chairman, Law Commissioner, and myself. Our secretaries and all that were always there. So we pondered over so many, ifs and buts, combinations and all that, and agreed on, it was a unanimous opinion that this judgment in Chandra Kumar's case would have defeated the object of the act. After all, you see, people are interested in speedy disposal.
Yes.
Well, where ordinary citizens will not know what is constitution, what is a judicial review, what is a basic feature of constitution. He wants to dispose of his case.
Yes.
But if that was not to be there, the government thought, in this high-powered committee meeting, that we may constitute or may provide an inter-court or inter-tribunal appeal. Because ultimately the objection of the Honorable Supreme Court is that there has to be judicial review of the orders passed by the tribunal, and which can be done by High Court.
But can't the Supreme Court do it right after the tribunal?
This is a provision.
Yes.
But this has not been agreed to by Supreme Court. And they say that High Court would have jurisdiction to have a judicial review orders passed by a CAT. Now, we suggested that, we in the meeting suggested that, well, if this is objection, let's have a judicial review within the court. And then the appellate bench may consist of only judicial members, or majority of them may be judicial, who are High Court judges, and to make some suitable amendments. The minutes were drafted about a year and a half ago. But well, I will say on the lighter side that government takes its time to do things.
Right, but
the things are there where they were 1.5 years ago.
But it is at least heartening to know that whether it's the government committee,
Yes.
whether it is the
Yes,
judiciary,
you are right.
whether it is the high-powered committee you mentioned, all are at least saying and seeing the tribunal as an effective substitute
It is.
for the high courts,
That's true.
because that is what will then meet the objective.
But I can tell you even now, even though there's a judicial review, by and large judgments given by CAT are upheld. And most of them are dismissed in the initial stages. The problem arises only where cases are admitted. And admission, if admitted, then 10 years, maybe more are gone.
But most of the cases that on which the judgment has come from the tribunal, now that the tribunal has been into existence for 26 years, is there a repetition of the case where the solution is that, okay, this is as per the order number such and such, or are there fresh cases every now and then?
No case can be decided like a performer. You see, of course, some law situations, law points crystallize. And when a similar law position comes into another case, it's easy to follow. We already held in so and so like this. But every case, by and large, has its own facts.
And since you talked about your team, tell us how you motivate your team, and when it comes to filling the vacancies, whether it is the judicial members or the administrative members, is that something that has happened to your fulfillment over the last 5 years?
It has, and Amit, I tell you, everyone has his own philosophy of working. Even as Chief Justice in CAT, and also in my tribunal in CAT, you said how they have been motivated. I have only one answer to say. I told my High Court judges also, and also my members, that I am a shock observer. Anything which comes upon you, I will take it. On lighter side, I said, but for matrimonial dispute. You work. You work in branch which you think you are specialist. I'll give you that. argue that subject. You know, there are different subjects. People are experts in different lines. I will give them a roster as per their choice and as per their expertise, and will keep them absolutely happy, meet all their possible demands, and that I thought was a sure way of success to take work out of them.
बिल्कुल, और बिल्कुल काम हुआ भी है, आपने काम लिया भी है टीम से। और आज जब हम चर्चा कर रहे हैं कि पिछले 5 साल में आपके कार्यकाल के दौरान क्या अचीवमेंट्स रही, तो जहां जुरिस्डिक्शन बढ़ा है, डिस्पोजल रेट की बात है, उसकी खुशी और आपको मुबारक हो। वहां पर अगर हम बात करें चैलेंजेस की, तो क्या चुनौतियां आप देखते हैं कैट के सामने अगले 4, 5, 10 सालों में?
Amit, you've taken a question which is very close to my heart. Well, so far so good. But there are some very significant developments, and the situation is not taken care of immediately. This institution, which is established by now and made its name for 25 years, is bound to go down in the conception of the people as an alternative to the High Court. What are those developments? You know, after say not after, say this about 4 or 5 years, an army tribunal, armed forces tribunal has come into being. Another tribunal known as Green Bench has come into being. There are tribunals working in state like Consumer Forum and Human Rights Commission, etc., etc., where retirement of a judge is the age of 70. In my tribunal, they retired them at the age of 65. The selection process takes time, by which 3 to 6 months of a judge of tenure of 3 years are gone by, and ultimately he is appointed only for a period of 2.5 years. After these tribunals came, my quiet is not maybe the last choice for a judge to get entry into it. And I'll give you statistics which are interesting. Last 5 years, in the selection committee headed by the Honorable Supreme Court Judge, at this time, Honorable Aftab Shri, sorry, we have made selection of say 35 judges, 40 judges, sorry. Out of them, 19 have either refused to join or after joining resigned. Because they are getting alternative appointment, alternative tribunals where retirement is after 8 years. In my tribunals, 2.5 years. So with the advent of time, position as on today's, the chairman of the Chief Justice, which I am, and I have only 8 judges out of 33 judicial members, only 8 judges. Rest are all lawyers. Now what has happened is another very significant thing. They made about amendment in 2006, and now they gave maximum 2 tenure of 5 years each to a lawyer. Now, no lawyer, you will understand,
Yes,
what's his name.
will come only for 5 years assured.
Well, assured is 5, not even 10.
Yes. Although it can be extended by another 5
It can,
years.
but it's not sure. It's not sure. Some members have gone out of 5 years. So no lawyer, what's his name, is joining tribunal. And I tell you, because of judges not joining, lawyers who are on the waiting list
Yes.
by default have come.
But the tenure is a problem there.
Now what is the scenario? Just see. CAT is manned by administrative members who have to be 1.5, 50%. So 33. Out of 33 judicial members, majority of them are lawyers. And lawyers who would have been doing something better in profession would have not come. Therefore, with all due respect to them, 2nd rank, 3rd rank, and sometimes even 4th rank lawyers.
That affects the quality. Affects the quality.
That will destroy the institution.
So one is this. Any other concerns? Any other thing that needs immediate attention?
This is the one which the solution
Yes.
is this. Now
Yes.
I may tell you, before I admit office, I am writing a letter. Half of it I have written
To the Prime Minister?
to the Prime Minister. He is the Honourable Minister for this, my department.
Yes.
I have talked to the Minister already. The concerned Minister,
Mr. Narayan Swamy.
Narayan Swamy, I have talked to him. good person. He is a background of a lawyer. He understood my viewpoint and he said, I'll talk to the Prime Minister. But meanwhile, I'm also writing a letter. And what I'm suggesting is that you improve the retirement age of a judge particularly, make it commensurate to or equal to the other tribunals, so that people may join my tribunal also.
Right.
And I tell you, the reputation of tribunal was primarily because half of it, a majority of half of it, were manned by High Court judges,
Yes,
who had experience of 5 years, 10 years. I had experience of 16 years.
and of course you were the chairman and you were the Chief Justice for Kerala High Court, so certainly. But as you demit the office this week, what next?
No, another thing which I am writing to the Honourable Prime Minister is this. There should be a retirement age for a lawyer also.
Okay.
Otherwise, you can't have a tenant. Talented lawyer will not come. You see, after 5 years, 10 years, if a lawyer may retire at the age of, say, 56 or something like that, would it be possible for him to go back to profession?
Certainly not.
So, therefore, you want to draw talent, make the institution an excellent institution, a vibrant institution.
So what's your proposal for the lawyer then? He gets a
They
term of-
must have a retirement age. You may have 60, 62, whatever government thinks, but not 10 or 5 years. Nobody will come.
Right.
And the tribunal will not be run by administrators and lawyers whom we are not selecting. They are coming by default.
Right. Even as we conclude this conversation with you, Justice Bali, and congratulate you on your tenure, what next? What's the next plan for yourself?
Me, myself, you see, in my hand is my profession.
So back to law?
Naturally.
After 21
But of
years in
course,
judiciary.
I am not interested in very complicated kind of a, but I can't sit at home either.
And of course, I know that you're a cricket buff. On the same show a couple of years back, you told me that you keep yourself posted with the updates. So what do you make of India's performance? We've lost badly in Australia.
Terrible, to say the least. Terrible.
Can we make a comeback in the Asia Cup?
I will always want it. I hope India win, always will.
And you plan to write a book as well?
Yes, I do.
On which subject?
Well, on my experience in judiciary that I have for 23 years as a lawyer and 21 years as a judge or chief justice or a chairman or CAT.
Well, we wish you all the best. Justice Bali, thank you so much for joining us
Thank
today
you,
on the
Amit.
program.
So nice
Thank
of
you
you.